You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 87, Willfully Infringing Someone's Patent. Don't do it. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com, or call me at 424-281-0162. In a past episode, I talked about patent infringement. That's when you make or use a patented invention without permission from the patent owner. And you can be liable for damages. If you copied someone's product that's covered by a patent and you made $1 million in profits, you may owe the patent owner $1 million. But you might actually even owe them more than that. Now, why would you owe them more than what you made by copying the patented invention? And it's because of something called willful infringement. If you copied someone's invention but had no idea that there was a patent on it, you could still owe them the lost profits, or you might owe them what's called a reasonable royalty. And it doesn't matter if you knew about the patent or not. But if you actually knew about the patent but just decided to go forward anyways, that's called willful infringement. But what does it mean to know about someone's patent? It sounds like an easy question. You either knew about a patent or you didn't know about a patent, right? Well, it's actually not so simple. What if you saw there was a patent, but you felt that you designed around it, so you weren't infringing, but then a court said that you didn't design around it enough? Is that willful? What if you saw this patent, but felt that the patent was actually invalid, and that a patent never should have been granted, and you decided to make the product anyways, because a judge would just invalidate the patent if it ever got to court? What if you got an opinion letter from an attorney that your product wasn't infringing? So on good faith, you made your product, but then a judge said that it was infringing. Is that willful if you relied on the attorney's opinion, but the attorney was wrong? Another example is, what if you thought there might be patents out there, but you decided that you were just going to bury your head in the sand and not look at patents because you didn't want to be accused of willful infringement? Can you get around it like that? And why does it actually matter anyways? It matters because if you are said to be willfully infringing someone's patent, you can owe up to triple the damages. So if you were found liable for $1 million in profits, the court may say that you owe the other party $3 million, and you could owe attorney's fees in exceptional cases too. Now, there were some old standards on what counted as willful infringement, called the objective recklessness standard, under what was called the Seagate Test from a court case that was in 2007. Before that, there was a different test, but we don't need to go into the whole history. The Seagate Test was a two-pronged test. The first part was objective. That means that the infringer acted despite an objectively high likelihood that his actions constituted infringement of a valid patent. And the second part was subjective knowledge, which means that the risk of infringement was either known to the accused infringer or so obvious that it should have been known. Now, a patent owner had to show this by clear and convincing evidence. Now, that's a standard below beyond reasonable doubt, but more than a preponderance of evidence, which is above 50%. So you couldn't even prove that more likely than not the infringement violated the standard. It had to be clear and convincing. Now, without going into all the details, this standard actually made it very difficult to show willful infringement because the defendant could just put forth a plausible argument about how it was reasonable to believe the patent was invalid or some other reason, believe that they designed around the patent, even if those defenses were unsuccessful. So after this, because a lot of people were getting away with what people thought was willful infringement, but they couldn't prove it, came another case called Halo Electronics Incorporated versus Pulse Electronics. And the Supreme Court got rid of that Seagate test and said it was too rigid and too many patent infringers were getting away with not having to pay increased damages. So in this new test, there's no objectively reckless standard. Now the standard is subjective willfulness of patent infringement. Intentional or knowing may warrant enhanced damages without regard to whether infringement was objectively reckless. That's a lot of legal language, but what does it mean in the real world? The standard really changed to focus on the willful misconduct rather than objective recklessness, and got rid of requiring the patent holder to present clear and convincing evidence as the standard of proof. Basically, it means that patent holders can more easily get triple damages. Now, the courts are going to focus on the infringer's state of mind. If you get an opinion from an attorney saying that your product doesn't infringe a patent, then subjectively, you believe that you're not infringing. It doesn't mean that you're required to get a legal opinion, but if you do get a legal opinion and that opinion says that you're not infringing, that's really helpful in showing your subjective state of mind that you're not infringing. But you may have other evidence as well showing that you did not mean to infringe a patent. So what steps should you do to avoid willfully infringing a patent? One is to consult a patent attorney to obtain an opinion. This shows that you had good faith in trying not to infringe a patent. Another thing to do is to conduct a reasonable investigation yourself by your staff and conduct patent searches yourself. And there's no slam dunk answer on what you need to avoid willful infringement because the facts in every scenario are going to be different and willful infringement is going to be very fact-based. But do your due diligence in documenting how you try not to infringe patents, and at least you can hopefully avoid willful infringement and triple damages. And at most get stuck with lost profits or reasonable royalties in case you do lose the patent infringement case. If you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.